I intend at this stage simply to tabulate and mention each of the documents or categories. It's the Heritage Impact Assessment of Hart and Townsend of July 2019. The Interim Comment of Heritage Western Cape of September 2019. The Supplementary Heritage Impact Assessment of December 2019. The UFMAS Report of November 2019. The Final Comment of Heritage Western Cape of February 2020. Then correspondence reflecting attempts of the Directorate to engage with Heritage Western Cape. The decision of the Director of August 2020. The appeal process. Then correspondence reflecting the Minister's attempts to engage with Heritage Western Cape, and then ultimately the Minister's decision on appeal on the 22nd of February 2021. And we submit that a perusal of these documents, as explained in the Minister's affidavit, will establish certain facts which cannot be disputed. All parties, including the respondents, accepted and agreed that the River Club site has high intangible heritage significance. This is reflected in the Director's decision and in the appeal decision quoted in the Minister's answering affidavit, and I'll simply give you the reference. It's volume 5, page 2144 and following. But, m'lady, these circumstances were in fact recognized from the outset. And we know that much reference has been made to the Heritage Impact Assessment itself, but I'm going to beg your indulgence by taking you there. It's in volume 6, and it starts at page 2402. It's Annexure AB9. This is the first Heritage Impact Assessment. And they start in paragraph 4.1 with the historical and geographical context. They start saying, what is clear from the historic record is that a number of the Khoi groups were wealthy in terms of the number of cattle they owned. Herds of several hundred to more than 1,000 head were recorded. Farming and moving a herd of this size is no simple task. And they go on to deal with the culture, the farming practices, the heritage of the Khoi before the colonizers arrived. And they go on to deal with it, for example, in the next paragraph. The early inhabitants of the Cape Peninsula farmed with cattle. Cattle need good quality soil, good grass, and fresh water. Therefore, understanding the environmental resources that were available is a key to understanding the way indigenous people use the landscape. He goes on, they go on the next page at 2436 to deal in the second paragraph with the Cape's unique geology, meaning they say that in certain areas the soils contain the necessary trace elements, copper and molybdenum, to raise cattle. And they indicate that there's a certain level of sophistication in their farming practices of the early Khoi in that they understood that at certain times of the year, certain plants were nutritious and they needed to be there. They then go on in this way to deal with the history and the encounters with the first colonizers and what was observed way back in 1652. And it's a detailed setting out of the history of the broader peninsula, the culture, farming practices, and so on, of the First Nations peoples. At 2438, they then, under the heading, the importance of the rivers, deal with the significance of the valleys of the Lisbeek and Black rivers, and then the rivers themselves. They deal with the significance of the rivers and how they were then changed over time. At 2440 and following, we have a heading, Roots of Conflict and the Commencement of Farming. And they deal in detail with the encounters between the Khoi groups and the first colonizers, dealing with respect quite accurately and in detail with what was in fact done by the first colonizers. We see, for example, the reference to the battle with the Portuguese Viceroy de Almeida. They say the account of his death indicates that the Khoi made great use of their cattle as weapons of intimidation to stampede over the Portuguese, the animals being apparently highly trained and responsive to the whistling of the Khoi. It's quite significant, and I think for anyone who is faintly aware of South African history, quite necessary to understand this level of military sophistication, including, and later, farming sophistication. There are detailed references to the encounters between the settlers, the Dutch settlers, and the Khoi, going right on to page 2444, where in paragraph 4.4 they deal with the defended boundary. The Dutch under Van Riebeeck setting up barriers excluding the Khoi from the land along the Liesbeek River with a hedge stretching to Wynberg. They deal in detail with the conflict that took place over that time. At 2448, they continue into the 19th and 20th century history of the site. Then, if I may take your ladyship to page 2471. This is paragraph 6 under the heading Identification of Heritage Resources. I'd like to take your ladyship to the middle of that paragraph, where they say, the exact places where incidents and confrontation occurred can never be known. But what is evident is that the historic landscape between the Black and Liesbeek rivers marks the site of one of the earliest frontiers that were to eventually herald the fragmentation of the Khoi nation. Although there are no tangible remnants of the actual places of conflict, forts, outposts, or graves, the topography and place survive, albeit greatly transformed by more recent layers of development. Wilderness and wetlands were transformed into farmland and then again to modern suburbia. On the other hand, the Liesbeek and Black rivers, the confluence and remnants of the Salt River estuary exist and are still identifiable as such. And in the context of the history of South Africa, this is an historic place of considerable significance. So we say, milady, that this report, read together with the supplementary report, is detailed, it's historically and culturally sensitive, and it is thorough. And this is demonstrated by the fact to which I'll come, that when Heritage Western Cape is ultimately asked what further information is required, they fail to identify any. So we submit that it does not assist the applicants to say repeatedly that the site has intangible heritage significance. This was and is common cause. It's also unhelpful for our learned friend, for the applicants, to seek to lecture the court on these topics. They're topics which are well known and which are not in dispute. The question confronting the director and the minister was the next one. Given these circumstances, what does one do about it? Or, put differently, what consequences should these circumstances have for the environmental decisions in terms of NEMA? The director and the minister explain their reasoning and their decisions, which amount to this. The site is degraded. The Liesbeek River is canalized, diverted from its original course, and is polluted. The site has been transformed over the years. It now has a golf course, a restaurant, and parking areas, all for private use. This does not reflect in any recognizable form the heritage which attaches to the site. The development can change this. There would be the rehabilitation of the Liesbeek River, the inclusion of conditions which will reflect and celebrate the site's heritage and its significance, including an indigenous garden, cultural heritage and a media center, a heritage eco trail, an amphitheater for cultural performances, and commemorating the history of First Nations peoples through names and symbols. Moreover, and importantly, a large portion of the site would be made accessible to the public, whereas it is now largely private. In other words, it would be opened up. One may, of course, disagree with their decisions. The residents of Observatory and certain representatives of certain First Nations people clearly disagree. But that does not make the decisions reviewable as a matter of basic legal principle. So, milady, we turn then to the case which the appellants attempt to put up. Of course, in the present context, we know the basic principles. There must be a prima facie right. They're open to some doubt. If there's serious doubt, they cannot succeed. And this, of course, is a threshold requirement. If they don't make it on this level, all of the rest is irrelevant. As pointed out by the other respondents, this right is not merely the right to review a decision. There must be some other substantive right for which protection is sought, and you've been addressed on that topic. But we address the question of whether the applicants have shown that the decisions are reviewable even on a prima facie basis, and the answer, as we will submit, is no. We start, milady, with the much-quoted central piece of legislation, the National Heritage Resources Act, and in particular, Section 38. Again, one's aware that you've been there, but I'm going to ask you to go there again. It's printed for the convenience of everyone in the founding affidavit, and it commences at page 33. And I'm going to ask your ladyship to go first to section 38.8, which is quoted on page 37. The consenting authority, here the director and the minister, must ensure that the evaluation fulfills the requirements of, and I'm going to say Heritage Western Cape, in terms of subsection 3. So that's a must. And then comments and recommendations of the Heritage Resources Authority must be taken into account. So those are the two different categories falling under the proviso to section 38.8. 38.3 is quoted at page 35 of the record. It says that the responsible Heritage Resources Authority, read Heritage Western Cape, must specify the information to be provided in a report required in terms of subsection 2A. So in other words, that is the report of the environmental practitioner. That is what the report must contain, provided that the following must be included. And then we have A to G, which set out the particular types of information which must be provided. Your ladyship will note that Heritage Western Cape's role here is in specifying information to be provided in a report. What is to be made of that information is not dealt with in terms of section 38.3. Let me give you an example, which I'm going to get to in a bit more detail later, and that relates to E. So going back to the proviso, provided that the following must be included. E, the results of consultation with communities affected by the proposed development and other interested parties regarding the impact of the development on heritage resources. What the section requires is that the results of consultation must be reflected in the report. The section does not tell us what those consultations should be. It, in fact, doesn't even say that there must be consultations. The requirement that there should be consultations will be sourced elsewhere. And that would be, for example, in Section 6 of PADGA. What is required here is that the results of consultations must be spelt out. And one understands why that is. The heritage, the environmental practitioner will say, this is what we have done in terms of consultation. Factually, right or wrong, this is what we have done. It will then be for the environmental authority to have regard to that and to say, well, I think that that is sufficient consultation or not sufficient consultation. What is clear is that whether or not the relevant information is provided is a factual question. It's not for the heritage authority to rule on it. So the notion that we see expressed quite firmly in the founding affidavit, that there was a usurpation by the environmental authorities of the power of Heritage Western Cape to say whether there had been compliance or not, is simply incorrect. The environmental authorities will determine whether there's been compliance on a factual basis. I'm not suggesting it's a discretionary matter, but Heritage Western Cape in these circumstances simply has no statutory power which can be usurped. So we know the references in the founding affidavit. You don't have to go there. I'm simply going to ask you to make a note. It's at page 98 to 99, paragraphs 198.2 and 199.2, where the notion of a usurpation is expressed. You can draw a line through that. It can't be the basis of the case. It's gone the way of the provisional protection order. What we see then in the founding affidavit is a misplaced attempt by these applicants, not Heritage Western Cape, to suggest that the information requirements of Heritage Western Cape in terms of section 38.3a to G were not met. The minister, in his answering affidavit, dealt with each allegation with reference to the relevant documentation, showing that all of the information requirements were met. I'm going to give you the reference now, and I'm going to get back to it. It's volume 5, page 2138 to 2151, and 2179 to 2185. So it's not surprising that this whole line of argument was not pursued in the appellant's heads of argument. But now, under new management, the appellants seek to resurrect this line. They don't succeed, and I'm going to get to it in detail in a moment as to why not. But what I'd like to deal with first is the one argument which we find in the heads of argument, which is repeated in the notes on oral argument which we saw yesterday morning. At page 31, 32 of the heads of argument, paragraph 25, we see an argument which stacks up as follows. The strong recommendation of the appointment of a further heritage specialist, and I'm using their words, rose to the level of an information requirement in terms of section 38.3. The argument is without substance, but I need to demonstrate that by going back to the papers, and particularly starting with the founding affidavit at page 70. The comment concludes with the strong recommendation that a specialist consultant with the requisite expertise in dealing with the intangible aspects pertaining to the wider TRUP area is engaged, and that a supplementary report from this consultant is incorporated into the second HIA. So on their version in the founding affidavit, it's a strong recommendation. There's no reference to it being an information requirement. Where do we find, sorry, before I answer that rhetorical question, now take your ladyship to Annexure LL10. It's at page 142, and it's perhaps necessary to look at the comment in its entirety. It's at page 152. This is after HWC has set out all of its complaints about the heritage impact assessment. They conclude in this way. Page 152. HWC finally notes that, notwithstanding the unquestionable qualifications and heritage standing of both heritage practitioners who compiled the report, that's Hart and Townsend, HWC is of the opinion that the HIA would benefit from input from a specialist consultant with the requisite expertise in dealing with the intangible aspects pertaining to the wider TRUP area. This input would assist in focusing on, in particular, the strong sense of place and meaning of the site pertinent to the First Nations representatives. It's a strong recommendation that a supplementary report from an expert in this field is incorporated into the HIA. So, with reference to the founding affidavit and Heritage Western Cape's letter, it's a strong recommendation, nothing more. But then comes time for a replying affidavit. May I take you, lady, and I must apologize for having to go to documents which I'm sure you're aware of, but nonetheless, it's volume 7. In any event, says Professor London, even if the minister's interpretation is preferred, and this court holds that HWC's only function in terms of 38.8 is to specify its information requirements, the NEMA authorities still failed demonstrably to ensure that, and now we have it, HWC's information requirements were met because they condoned LLPT's failure to procure and submit a supplementary report from an expert in intangible heritage. So what starts with a strong recommendation morphs in reply into an information requirement. The problems with their approach. The first is a purely procedural one. This was not raised in the founding affidavit as a review ground, and it should be struck out in reply. Your ladyship is aware of our application for striking out. It's in volume 8, page 3128. We move for such an order. On its own terms, this was a recommendation, not an information requirement. It cannot be massaged into one. Section 38.3 on its own terms simply doesn't apply. This is not about information. It's about a potential source of unspecified information. Our learned friend says, straight out of the blocks on this topic, as pointed out above, HWC in its letter of 13 September 2019 required the provision of a supplementary report. They did nothing of the sort. It was a recommendation. And at page 47, we see an argument which proceeds along the following lines, pursued during oral argument. There's a reference to the director's letter, and it said that the director conceded or admitted or said that in fact this was an information requirement. You'll see the letter at page, it's Annexure AB4. Don't go there, my lady. It's at page 2, 3, 3, 5, and 6 of the record. Didn't go there because we have its salient parts quoted for our convenience at page 47 of the applicant's heads of argument. But the point to be made is this. Nowhere does the letter say that the recommendation regarding provision of a further report is in itself an information requirement. It doesn't say that. And it's not one. It's not put up as one in the founding Act. And it's important, we would submit, to see how this matter developed from there. At page 26 of our heads of argument from paragraph 45, and again, my lady, you may go there if you'd like to, but I'm sure you're aware of it, and I'm going to simply give you the substance. We deal with the engagements with Heritage Western Cape and the responses to their criticisms of the heritage impact assessment. In the oral note of our learned friend at page 54, we find a criticism of the response of the heritage consultants, where it said that the tone and the content of their report in response was, and then various words are used, problematic and the like. 2 points. First, no basis is provided for suggesting that the response of the consultants was not correct. In particular, information requirements were met. The second point is that Heritage Western Cape itself doesn't come to court to complain about this in any way. There's no basis for these applicants to do so, seeking to ride on the back of an absent litigant. The matter is then picked up by the minister. And again, we deal with this in our heads of argument at page 31. Essentially, the question posed by the minister on appeal to Heritage Western Cape is, what information do you say still has to be provided? What is their response? They fold their arms. The minister asks again and says, if you don't respond, I will then have to decide this matter on what is before me. We get confronted with bold disagreement. So Heritage Western Cape is given every opportunity to answer a simple question to assist the decision maker. What further information is required? And they don't answer. And they don't come to court to say what that information is. So this line with respect that the recommendation somehow transmuted itself into an information requirement has no substance.